The wills question from February of 1998 was an interesting question, and it's a straight wills question. There are no issues from trusts in this question. Have a look at the call of the question. 1. Was T's will validly executed? Discuss. Well, we can outline a basic framework for analyzing this call of the question without even reading the fact pattern. We know that to establish the validity of a will, we focus on capacity, intent, and formalities. 2. Assume T's will was validly executed. How should T's estate be distributed? Discuss. Well, we can't really organize an answer to question 2 without reading the fact pattern. But we do know this. Whenever we're asked about a distribution series of issues, we will typically organize them around either the beneficiaries or around objects that are subject to distribution under the estate. So now let's go to the top of the question and have a look at it. In paragraph 1, we find out about testator. She's a widow, she's got 2 adult children, and she executes a typewritten will with the following 3 provisions. $100,000 to son, farm to friend 1 and friend 2, share and share alike. One wonders, does that mean a joint tenancy? Then, number 3, residue to daughter. Okay, that's pretty straightforward. We look at the next paragraph and we see that there's a problem with the formalities. The testator signs in the presence of son and witness. Well, there's a problem to have a witness who also is a beneficiary. So we're going to have to focus on that problem more when it comes to distribution, because there's going to be a presumption of undue influence. But for the purposes of validity, having a witness who also is a beneficiary does not undermine the validity of that will itself. What it undermines is the validity of the gifts to the interested witness. Next, we find out that the witnesses understood that the document was the testator's will and signed as a witness. We are told that the testator had capacity and was not subject to duress, fraud, or undue influence, or coercion, or other pernicious influence. Now, what that tells us is that the son ought to be able to rebut the presumption of undue influence based on the true facts, and he ought to be entitled to whatever share we decide he's entitled to. Then, in 1997, in the following paragraph, we see that the testator and the daughter were killed instantly in an automobile collision. The will was found in a safety deposit box, and there appears to be some effort to revoke by physical act. There's a line drawn through the part of paragraph 2 that tries apparently to take away friend number 2 as a beneficiary. Next, we see that the daughter is survived by her husband, but no issue. The daughter has no will. The estate consists of $100,000 in cash, the farm worth $50,000, and other property worth $100,000. It's very simple and straightforward. We are asked the 2 calls of the question and told to apply California law. Okay, well, that's not such a big problem, and as predicted, the distribution issue is the more complicated. Now, please turn and have a look at the outline of issues that I present, and we'll see that with regard to validity, I don't really do anything more than we were able to intuit when we first read the call of the question. We focus on capacity and intent. We go into formalities. Since we do have a special problem with an interested witness, I give that a separate section. And then we reach a predictable conclusion that this will was validly executed. Then we move on to consider distribution. Here, to begin with, I organize by the gifts. I focus on the gift to the son, then I focus on the farm. And here we've got to deal with the attempted revocation by physical act and the issue as to whether or not this revocation would increase the share of the first friend. Then we focus on the residue of the estate to the daughter. We focus on the simultaneous death issue. I had a professor that used to call that concurrent croaking. And we deal with lapse and anti-lapse. Next, we turn to intestacy for a short section, and finally we reach a global conclusion. So we see this is not a complicated question, and it's also not a difficult question if you know the law. And if you're learning the law by using this seminar, there are certainly some pieces here that are going to contribute to your understanding the whole puzzle of California wills and trusts law. Now, let's focus on my answer and have a look at it for a couple minutes. You'll see, up front with regard to capacity and intent, I lead with the fact that she had testamentary capacity. I focus then on the facts and I establish her intent. And I quote from the facts about how she was not subject to duress, etc. She knew her property, she knew the objects of her bounty. Capacity and intent are satisfied. With regard to formalities, you'll notice up front, for a change I lead off with some law. I indicate what the requirements are for a formal witnessed will. And then I focus on the problem involving the son as an interested witness. Under the old rules, one interested witness without two disinterested witnesses equals an invalid will. But the modern approach is to consider the will valid, but to bring the gift of the interested witness into question. And I'll focus on that fact below, but ultimately I'm going to conclude that the testator's will was validly executed. Then we go to distribution, and we focus first on the key facts, which is that the testator and her daughter were killed instantly in a car accident, and that the will was found in the safety deposit box with an alteration. So, first, we focus on the gift of $100,000 to the son. You'll notice that I dispense with this issue in about 3 sentences. I establish that he was an interested witness, that he is able to overcome this presumption of undue influence based on the facts that are basically stipulated to us, and so I conclude that he does take the $100,000 under the will. Next, we focus on a more complicated issue, the farm. I lead with the facts indicating what the provision is, and that at the time it was executed, it was a valid gift in the will. Then we focus on the revocation by physical act. It seems at a minimum that she would intend to revoke the gift to friend 2. And it's also possible that this one line could invalidate the entire document. In any case, the partial revocation of the gift to the second friend will not serve to increase the gift to the first friend because it has not been expressly increased. And so friend 1 still takes the same share that he would have taken had the provision been upheld in its entirety. He gets 1/2. The other half falls to the residue. So now we consider that issue. We focus on the residue gift to the daughter. And we've got a simultaneous death issue. Now, for the purposes of analysis, we're going to presume that the daughter predeceased the testator for purposes of distribution. This causes the gift to lapse unless it is protected by the anti-lapse statute. This subject is very commonly tested on California Bar Wills and Trusts essay questions. So, we focus on the anti-lapse statute. California's anti-lapse statute is more broad than the national version. It's broad enough to protect the husband. So here, the daughter was married without issue. So the California anti-lapse statute will award this gift to the husband as the survivor. Next, I briefly focus on intestacy. If there was some fatal flaw with this will, then the son would take everything as the sole intestate heir. Ultimately, I reach a very narrow and specific conclusion which wraps up an analysis of the entire fact pattern. I find that the will was valid. I find that the son takes the $100,000 gift that was bequested to him under the will. I find that the first friend takes 1/2 of the farm as a tenant in common with the residuary beneficiary, the son. I'm sorry, not with the residuary beneficiary, but just with the son. And the gift to the daughter does not lapse, and the residuary goes to her husband.